Hi everyone, my name is Melody Carabido. So for today, I will discuss and teach you about the different kinds of obligation, a pure and a conditional obligation. So pure obligation is one which is not subject to any condition and no specific date is mentioned for its fulfillment and is therefore immediately demandable. So ang ibig sabihin nito, ang isang purong obligasyon daw ay isang hindi napapailalim sa anumang kondisyon at walang tiyak na petsa na binanggit para sa katuparan nito at sa makatuwid ay agad na hinihiling. So, meaning of conditional, condition is a future and uncertain event upon the happening of which the effectivity or the extinguishment of an obligation or right, subject to it depends. So, ang kondisyon ay isang hinaharap at hindi tiyak na kaganapan kung saan ang kaganapan ay nakasalalay sa pagiging epektibo o pag-alis ng isang obligasyon o karapatan na napailalim dito. So, characteristics of a condition. One is a future uncertain and uncertain. In order to constitute an event as condition, it is not enough that it be future, it must be also be uncertain. The first paragraph of Article 1179 obviously uses the disjunctive or between future and uncertain to distinguish pure obligation from both a conditional obligation and one with a period, be that as it may the word or should be. And so, ito yung upang makabuo daw ng isang kaganapan bilang isang kondisyon, hindi sapat na ito ay hinaharap, ito ay dapat ding hindi sigurado. So, ang unang talata ng Artikulo 1169 ay tumutukoy sa malinaw na gumagamit ng disjunctive na o sa pagitan ng hinaharap at hindi tiyak upang makilala ang purong obligasyon mula sa parehong kondisyon na obligasyon at isa na may isang panahon kagayunman ang salitang o ay dapat na 2. Past but unknown. A condition may refer to a past event unknown to the parties. If it refers to a future event, but its very occurrence and the time of such occurrence must be uncertain. Otherwise, it is not a condition. So, ibig sabihin, ang isang kondisyon ay maaaring tumutukoy sa isang nakaraang kaganapan na hindi alam ng partido. Kung ito ay tumutukoy sa isang kaganapan sa hinaharap, ang mismong litaw na ito, ang oras ng naturang pangyayari ay dapat na hindi tiyak kung hindi ito ay hindi kondisyon. So, two principal kinds of condition. They are 1. Suspensive condition, a condition precedent or condition antecedent, or one the fulfillment of which will give rise to an obligation or right. In other words, the demandability of the obligation is suspended until the happening of the uncertain event which constitute the condition. So, ito yung isa sa naang katuparan nito ay ang magbubunga ng isang obligasyon o karapatan. Sa madaling salita, ang demandability ng obligasyon ay sinuspindi hanggang sa may mangyari ang hindi tiyak na pangyayari na bumubuo sa kondisyon. So, 2. Resolutory condition. Condition subsequent or other or one of the fulfillment which will extinguish an obligation or right already existing. So, sunod na kondisyon o isa na ang katuparan nito ay buksain ng isang obligasyon na umiiral na. So, distinction between subpensive and resolutory condition. The difference between the two is condition is very clear. Both bear influence on the existence of the obligation but in diametrically opposed manner. 1. If the suspensive condition is fulfilled, the obligation arises, while if it is the resolutory condition that is fulfilled, the obligation is extinguished. So, kung ang suspensive condition ay natupad, ang obligasyon ay bumangon, habang kung ito ay ang resolutory condition na napatupad, ang obligasyon ay pinapatay. So, if the first does not take place, the tie of the law, juridical or legal tie, does not appear, while if it is the other, the tie of law is consolidated. Ibig sabihin is kung hindi ginaganap ang una, hindi lalabas ang pagkakatali ng batas. Humikal o legal na pagkakatali habang kung ito naman ang iba, ang pagkakatali ng batas ay pinagsama-sama. So 3. Until the first take place, the existence of the obligation is a mere hope, while in the second, its effects flow. But over its hover, the possibility of termination. So hanggang sa maganap ang una sa pagkakaroon ng obligasyon na isa pang asa lamang habang sa pangalawa, ang mga epekto nito tumalayo ngunit sa ibabaw nito ay umaasa ang posibilidad ng pagwawakas. When obligation is demandable at once, an obligation is demandable at once when it is pure, when it's subject to resolutory condition, or when it's subject to resolutory period. So, past event unknown to the parties. A condition refers only to uncertain and future event. A past event cannot be said to be conditioned since the demandability of an obligation subject to a condition depends upon whether the event will happen or will not happen. So, ang isang condition daw ay talagang tumutukoy lamang sa isang hindi tiyak at hinaharap na kaganapan. Ang isang nakaraang kaganapan ay hindi masasabing isang kondisyon dahil ang demandability ng isang obligasyon na nagpapailalim sa isang kondisyon ay nakasalalay sa kung kaganapan ay mangyayari o hindi mangyayari. So, Article 1180, when the debtor binds himself to pay, when his means permit him to do so, the obligation shall be deemed to be one of a period subject to a provision of Article 1197. 11. Kapag ang may utang daw ay hindi nagtali sa kanyang sarili na magbayad kapag ang kanyang kayamanan ay nagpapahintulot sa kanya na gawin ito, ang obligasyon ay dapat ituring na may isang panahon. Napapailalim sa mga provision ng Artikulo 1197. For duration of period depends upon the role of debtor. Period is a future and a certain event upon the arrival of which the obligation subject to it either arises or extinguishes. The debtor promised to pay when his means permit him to do so. The obligation shall be deemed to be one of the period. In this case, what depends upon the debtor's will is not whether he should pay or not, for ended he finds himself to pay. What is left only to his will is the duration of the period. If the debtor and the creditor cannot agree as to the specific time for payment, the court shall fix the same on the application of its party. So, nangako ang may utang na magbabayad kapag pinahintulutan siya ng kanyang kayamanan. Ang obligasyon ay ituring na may panahon sa kasong ito. Ang nakasalalay sa kalooban ng may utang ay hindi kung dapat natin bayaran o hindi sa katunayan siya ay nagtali sa kanyang sarili upang magbayad. Ang natitira lamang sa kanyang kalooban ay ang pagtagal ng panahon. Kung may utang at ang pagkakautangan ay hindi magkakasundo tungkol sa tiyak ng oras para sa pagbabayad, ang hukuman ay dapat ayusin ng pareho sa aplikasyon ng alinmang partido. Other cases, as when the debtor binds himself to pay a little by little, as soon as possible, from the time to time, anytime have the money, or in partial payments. So, also, when I am in a position to pay acquisition of rights in obligations subject to a suspensive condition, the acquisition rights by a creditor depends upon the happening of the event when concession the condition. So, ibig sabihin, sa mga obligasyong napapailalim sa isang suspensive na condition, ang pagkuha ng mga karapatan ng pinagkakautangan ay nakasalalay sa pangyayari na bumubuo sa kondisyon. So, what characterizes this kind of obligation is the fact that its efficacy or obligatory force, distinguished from its demandability, is subordinate to the happening of a future and uncertain event. It follows that if the suspensive condition does not take place and it's certain that it will not fulfill, the parties would stand as if conditional obligation had never existed. During the dependency of suspensive condition, the creditor has only a mere hope or expectancy of acquiring a right. So, ibig sabihin is ang nagpapakilala sa ganitong uri ng obligasyon ay ang katunayan na ang bisa o obligadong puwersa nito tulad ng pagkakaiba o sa demandability nito ay nasa ilalim ng mangyayari sa isang hinaharap ang hindi tiyak na kaganapan. Kasunod nito, na kung hindi magaganap ang suspensive condition at tiyak na hindi ito matutupad, ang mga partido ay tumatayo na parang ang kondisyon na obligasyon ay hindi kailanman umiral. Sa panahon ng pendency ng suspensive condition, ang pinagkakataon ay mayroon lamang pag-asa o pag-asa na makakakuha ng karapatan. So, lost rights already acquired in obligations subject to a resolutory condition, the happening of the event which constitutes the condition produces the extinguished or loss of rights are already acquired. Sa mga obligasyong napapailalim sa isang resolutory condition, ang kaganapan ng kaganapan ay bumubuo sa kondisyon ay nagbubunga ng pagpuksa o pagkawala ng mga karapatan na nakuha na. So, Article 1182, when the fulfillment of the condition depends upon the sole will of the debtor, the conditional obligation shall be void if it depends upon chance or upon the will of a third person. The obligation shall take effect in conformity with the operation of this code. So, kapag ang katuparan ng kondisyon daw ay nakasalalay sa tanging kalooban ng may utang, ang walang bisa ng kondisyon ng obligasyon kung ito ay nakasalalay sa pagkakataon o sa kalooban ng ikatong tao, ang obligasyon ay magkakabisa alinsunod sa mga provision ng kodigong ito. So, classification condition may be classified as follows. As to effect, Suspensive, the happening of which gives rise to obligation, and ito yung ang nangyayari ay nagdudulot ng obligasyon. B. Resolutory, the happening of which extinguishes the obligation. So, pagyari ay pumapatay sa obligation. As to form, the condition is clearly stated. Implied the condition is merely inferred. 3. As to possibility, A. Possible, the condition is capable of fulfillment legally and physically. B. Impossible, the condition is not capable of fulfillment legally or physically. 4 as the cause or origin. A. Potestative, the condition depends upon the will of one of the contracting parties. Casual, the condition depends upon chance or upon the will of a third person. And C. Mixed, the condition depends partly upon chance and partly upon the will of a third person. So as to mode, positive, the condition consists in the performance of an act. And B. Negative, the condition consists in the omission of an act. 6. As to numbers, nakapaloob dun is A. Conjunctive, there are several conditions and all must be fulfilled. B. Disjunctive, there are several conditions and only one or some of them must be fulfilled. 7. As to divisibility, divisible, the condition is susceptible of partial performance. And B. Indivisible, the condition is not susceptible or a partial performance. So, potestative condition, a condition suspensive in nature and which depends upon the sole will of one of the contracting parties is known as the potestative condition. So, ang isang kondisyong suspensive sa kalikasan ay nakasalalay sa tanging kagustuhan ng isa sa mga partidong nakikipagkontrata ay kilala bilang potestative condition. When suspensive condition depends upon will of debtor, conditional obligation void. For the prestative condition depends solely upon the will of the debtor, the conditional obligation shall be void because its validity in compliance is left of the will of the debtor, and it cannot therefore be easily demanded in order not to be liable. The debtor will not just fulfill the condition, there is no burden on the debtor and consequently no juridical ties is created. So kung saan ibig sabihin is kung saan ang potestative condition ay nakakasalalay lamang sa kagustuhan ng may utang, ang kondisyonal na obligasyon ay dapat walang bisa dahil ang bisa at pagsundo nito ay pinapaubaya sa kagustuhan ng may utang. Ito ay nakabase sa Article 1308 at hindi ito sa makatuwid ay madaling hilingin upang hindi managot ang may utang, hindi basta-basta matupad ang kondisyon. Walang pasanin na sa may utang at dahil dito walang nabuong juridical tie. 2. Only the condition void if the obligation is a pre-existing one and therefore does not depend for its existence upon the fulfillment of the debtor of the potestative condition. Only the condition is void, leaving unaffected the obligation itself. Here, the condition is imposed not in the birth of the obligation but on its fulfillment. So, ibig sabihin, kung ang obligation ay isang nauna nang umiiral at sa makatuwid ay hindi nakasalalay sa pagkakaroon nito sa pagtupad ng may utang sa potestative na condition, tanging ang kondisyon ay walang bisa at hindi naapektuhan ang obligasyon mismo. Dito, ang kondisyon ay pinapataw hindi sa pagsilang ng obligasyon kundi sa ito katuparan. So, where suspensive condition depends upon will of creditor. The condition depends exclusively upon the will of the creditor. The obligation is valid. So, kung ang kondisyon ay nakasala lamang sa kakusahan ng pinagkakutangan, obligasyon ay may bisa. So, where resolutory condition depends upon will of the debtor. If the condition is resolutory in nature, like the right to the further purchase in a sale, with fact to the retro, the obligation is valid true. Although its fulfillment depends upon the sole will of the debtor or the seller, the fulfillment of the condition merely causes the extinguishment of loss of rights already acquired. So, Article 1181, the debtor is naturally interested in its fulfillment. The position of the debtor when the condition is resolutory is exactly the same as that of the creditor when the condition is suspensive. So, kung ang kondisyon ay likas na mapagpasyahan tulad ng karapatang muling bumili sa isang pagbebenta na may pacto directo, ang obligasyon ay may bisa kahit na ang katuparan nito ay nakasalalay sa tanging kagustuhan ng may utang magbebenta. So, ang katuparan ng kondisyon lamang naging sanhi ng pagpupuksa pagkawala ng may karapatan na nakuha na. Article 1181. Ang may utang ay likas na interesado sa katuparan nito. Ang posisyon ng may utang kapag ang kondisyon ay resolutory ay eksaktong kapareho ng sa pinagkakautangan kapag kondisyon ay suspensive. Casual condition, if the suspensive condition depends upon change or upon the will of a third person, the obligation subject to it is valid. So, kung ang suspensive na condition daw ay nakasalalay sa pagkakataon na sa kalooban ng tatlong tao, ang obligasyon ay pailalim dito sa wasto. So, Mixed condition. The obligation is valid if the suspensive condition depends partly upon the will of a third person. So, ang obligasyon ay may bisa kung ang suspended na condition ay bahagyan nakasalalay sa pagkakataon at bahagyan sa kaloob ng isang pangatlong tao. So, where suspended condition depends partly upon will of the debtor. According to Manresa, the use of the word inclusive now so makes it clear that condition obligation whose fulfillment depends partly upon the will of the debtor and partly upon the will of the third person are upon the change of perfectly valid Jacinto versus Chua. So, ayon kay Manresa daw, ang paggamit daw ng salitang eksklusibo, ngayon ay nag-iisang ay nililinaw na ang mga obligasyon may kondisyon ay na ang katuparan ay bahagyang makasalalay sa kagustuhan ng may utang at bahagyang sa kagustuhan ng ikatong tao o kapag nagkataon ay ganap na gusto. So, it is believed, however, that if the compliance with the obligation still depends upon the part of the condition whose fulfillment depends upon the will of the debtor, the obligation is void as is within the power to comply or not to comply with the same. The situation is the same as if the condition depends entirely upon the will of the debtor. So ito yung paniniwala ni gayon pa man na kung ang pagsunod sa obligation ay nakasalalay pa rin sa bahaging iyon ng iyong kondisyon na ang katuparan ay nakasalalay sa kagustuhan ng may utang, ang obligasyon ay walang bisa dahil ito ay nasa kanyang kapangyarihan na sumunod o hindi. So sumunod sa pareho, ang sitwasyon ay katulad na kung ang kondisyon ay ganap na nakasalalay sa kalooban ng may utang. So, Article 1183, impossible condition thus contrary to good custom or public policy and thus prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, the part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition na to do is possible thing shall be considered as not having been agreed upon. So, ang mga imposibleng kondisyon ay ang salungat sa mabuting kaugulan ng patakaran pampubliko ay ang ipinagbabawal ng batas at magpapawalang bisa sa obligasyong nakasalalay sa kanila. Kung obligation ay mapahati ang bahaging iyon, ito na hindi apektado ng imposible o labag sa batas sa kondisyon ay maagiging wasto. Ang kondisyon na hindi gumawa ng imposibleng bagay ay ituring na hindi pagkakasunduan. When Article 1183 applies, Article 1183 refers to expansive condition. It applies only to cases where the impossibility already existed at the time the obligation was constituted. If the possibility arises after creation of the obligation, Article 1266 governs. Ang Artikulo 1183 ay tumutukoy sa mga suspended na condition. Nalalapat lamang ito sa mga kaso kung saan ang posibilidad ay umiiral sa oras na nabuo ng obligasyon. Kung ang posibilidad ay lumitaw pagkatapos ng paglikha ng obligasyon, Article 1266 mamahala. So, two kinds of impossible conditions. So, they are physically impossible conditions. So, it is when they are nature of things that cannot exist or cannot be done. And where to is legally impossible condition when they are contrary to law, moral good customs, public order, or public policy. Effects of impossible condition. Conditional obligation, void. Impossible condition, annulled obligation which depends upon them. Both the obligation and the condition are void. The reason behind the law is that the obligor knows his obligation cannot be fulfilled. He has no intention to comply with his obligation. So, ang mga imposibleng kondisyon ay nagpapakulang bisa sa obligasyon na nakasalalay sa kanila parehong walang bisa ang obligasyon at kondisyon. Ang dahilan sa likod ng batas ay alam ng obligor ang kanyang obligasyon hindi matutupad. Wala siyang balak sumunod sa kanyang obligasyon. So, conditional obligation valid if the condition is negative, that is not to do an impossible thing. It is disregarded and the obligation is rendered pure and valid. Actually, the condition is always fulfilled when it is not to do an impossible thing so that it is the same as if there were no condition. Kung ang condition ay negatibo, iyon ay hindi upang gawin ng isang imposibleng bagay. Ito ay binabaliwala at ang obligasyon ay ginawang dalisay at wasto. Sa totoo lang, ang kondisyon daw ay palaging natutupad kapag ito ay hindi upang gawin ang isang imposibleng bagay. So, upang ito ay katulad ng kung walang kondisyon. 1. Only the affected obligation void if the obligation is divisible. The part thereof not affected by impossible condition shall be valid. 2 is the only the condition void if the obligation is a pre-existing obligation and therefore does not depend upon the fulfillment of the condition which is possible for its existence. Only the condition is void. So, obligasyon ay isang umiiral na obligasyon at sumakatuwid ay hindi nakasalalay sa katuparan ng kondisyon na imposible para sa pagkakaroon nito ang kondisyon lamang ng walang bisa. So, Article 1184, the condition that some event happen at a determinate time shall extinguish the obligation as soon as the time expire or if has become inevitable, that event will not take place. Ibig sabihin is, ang kondisyon ay na ang ilang kaganapan ay nangyari sa isang tiyak na oras ay dapat patayin ang obligasyon sa sandali matapos ang oras o kung ito ay naging hindi mapag-alala na ang kaganapan ay hindi magaganap. Positive condition, the above article refers to positive suspensive condition, the happening of an event at a determinate time, the obligation is extinguished as soon as the time expires without the event takes place or ibig sabihin ito, isa sandaling matapos ang oras ng hindi nagaganap ang kaganapan. Number 2, as soon as it becomes inevitable that the event will not take place although the time specified has not expired. So, sa sandaling ito ay naging hindi mapag-anilangan ang kaganapan na hindi magaganap kahit na ang oras na tinutukoy ay hindi na expired na. So, Article 1185, the condition that some event will not happen at a determinate time shall render the obligation effective from the moment the time indicated has elapsed or if it has become evident that the event cannot occur. If that time has been fixed, the condition shall be deemed fulfilled at such time as may have probably been contemplated bearing in mind that nature of the obligation. So, ibig sabihin sa kondisyon na ang ilang kaganapan ay hindi mangyayari sa isang tiyak na oras ay magbibigay ng obligasyon na epektibo mula sa sandaling ang oras na pinahiwatig ay lumipas at kung ito ay ang naging maliwanag na hindi maaaring mangyari ang kaganapan kung walang oras na naayos ang kondisyon ay tinuturing na natupad sa oras na maaaring mangyari pinag-isipan na isiniya sa isip na ang likas na katangian ng obligasyon. So, negative condition. The above provision speaks for a negative condition that an event will not happen at a determinate time. The obligation shall become effective and binding. So, from the moment of the time indicated has elapsed without the event taking place or mula sa sandaling ang oras na ipinapahawatig ay lumipas nang hindi nagaganap ang kaganapan. 2 is from the moment if thus become evident that that event cannot occur although the time indicated has not yet elapsed. So, mula, sandaling ito ay naging maliwanag na ang kaganapan ay hindi maaaring mangyari, kahit na ang oras na ipinahawatig ay hindi lumipas pa. So, Article 1186, the condition shall be deemed fulfilled when the obligor voluntarily prevent its fulfillment. Ang kondisyon ay dapat tinuring na natupad kapag ang obligor ay kusang loob na madlang sa katuparan nito. Constructive fulfillment of suspensive condition. There are 3 requisites for the application of this article. A. The condition is suspensive. B. The obligor actually prevents the fulfillment of the condition. And C. He acts voluntarily. Constructive fulfillment of resolutory condition. An Article 1186 applies also to an obligation subject to a resolutory condition with respect to the debtor who is bound to return that he has received upon the fulfillment of the condition. So, ang Artikulo 1186 ay naglalapat din sa isang obligasyon na pailalim sa isang resolutory na condition na may kinalaman sa may utang na nakatakdang ibalik ang kanyang natanggap sa katuparan ng condition. So, Article 1187, the effects of conditional obligation to give once the condition has been fulfilled shall retroact to the day of the completion of the obligation. Nevertheless, when the obligation imposed reciprocal prestation upon the parties, the fruits and interest during the pendency of the condition shall be deemed to have been mutually compensated. The obligation is unilateral. The debtor shall appropriate the fruits and interest received unless from the nature and circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. An obligation to do and not to do, the courts shall determine each case. The retroactive effect of the condition that has been complied with. So, sa makatuwid, ang epekto ng isang condition, ibig sabihin lang ito is na ibigay kapag matupad na ang condition ay dapat mag-retroact sa araw ng kontestasyon ng obligasyon. So, gayon pa man, kapag ang obligasyon daw ay nagpapataw ng kapalit na prestation sa mga partido, ang mga bunga at interes sa panahon ng dependency ng kondisyon ay dapat itunuring na kapwa na bayaran. Kung obligation ay dapat itunuring na Kung obligation ay unilateral, ang may utang daw ay dapat iakma ang mga bunga at interes na natanggap maliban kung mula sa kalikasan at mga pangyayari ng obligasyon ay dapat na minuha ng insensyon ng taong bumubuo nito ay iba. So, sa mga obligasyong gawin at hindi dapat gawin, ang mga hukuman ay dapat nagpasya sa bawat kaso. Ang retroactive epekto ng kondisyon ay nasunod. Retroactive effects sa fulfillment of suspensive condition. Ang ibig sabihin is an obligation to give is subject to suspensive condition becomes demandable only upon the fulfillment of the condition. So, however, once the condition is fulfilled, its effect shall retroact the day when the obligation was constituted. The reason is because the condition is only an accidental element of a contract. An obligation can exist without being subject to a condition. Had the parties known before and that condition would fulfill, they would have bound themselves under the pure obligation. Hence, the obligation should be considered from the time its condition should end, not from the time the condition is fulfilled. So, ang ibig sabihin sa mga obligasyon na ang isang obligasyon na magbigay na napapailam sa isang suspensive na condition ay maging hinihiling lamang kapag natupad ang kondisyon. Gayunpaman sa sandaling matupad ang kondisyon, ang mga epekto nito ay dapat mag-retroact sa ang araw kung ilan nabuo ang obligasyon. So, ang dahilan daw ay dahil ang kondisyon ay isang aksidenteng elemento lamang ng isang kontrata. So, ang isang obligasyon ay maaaring umiiral ng hindi napapailalim sa isang kondisyon kung ang mga partido ay nalaman ng maaga na ang kondisyon ay matutupad. Sila ay nakatali sa kanilang sarili sa ilalim ng isang purong obligasyon. Sa makatuwid, ang obligasyon ay dapat isalang-alang mula sa oras na ito ay nabuo at hindi mula sa oras na ang kondisyon ay natupad. Number 2 is an obligation to do or not to do. Ayan na. With the respect of the retroactive effect of the fulfilled suspensive condition in obligation to do or not to do, the fixed rule is provided. This does not mean, however, that in this obligation the principle of retroactivity is not applicable. The court are empowered by the use of the sound discretion and bearing in mind the intent to the parties to determine each case. The retroactive effect, the suspensive condition that has been complied with, it includes the power to deceive that the fulfillment of the condition shall have no retroactive effect or from what date such as retroactive effect shall take effect. So, ito yung kaugnayan ng retroactive na epekto ng katuparan ng isang suspensive na condition sa mga obligasyon gawin o hindi gawin. Walang nakaperming tuntunin ang binigay. Hindi ito nangangahulugang gayon pa man sa mga obligasyon. Ito ang prinsipyo ng retroactive ay hindi naangkop. So, ang mga hukuman daw ay binibigyan kapangyarihan sa pamamagitan ng paggamit ng tamang pagpapasya at isinasa-isip ang layunin ng mga partido na matukoy sa bawat kaso ang retroactive na epekto ng suspensive na kondisyon na nasunod. So, kabilang dito ang kapangyarihang magpasya ng katuparan ng kondisyon ay hindi magkaroon ng retroactive effect o mula sa anong petsa ng naturang retroactive ay magkabisa. So, retroactive effects of the fruit and interest and obligation to give. One is an reciprocal obligation. There is no retroactive because the fruit and interest are received during the tendency of the condition are done to have been mutually compensated. Ibig sabihin ito is walang retroactive retroactivity dahil ang mga bunga at interes na natanggap sa panahon ng dependency ay condition ay tinuturing na kapwa na bayaran. Ang panuntunang ito ay kinakailangan para sa mga layo na kaginawa dahil ang mga partido ay hindi kailangan magbigay ng mutual accounting ng kung ano ang kanilang natanggap. So, ang mga prutas dito ay maaaring natural, pang-industriya o civil na prutas. Number 2 is in unilateral obligation. There's usually no retroactive effect because they are already choose the debtor receive nothing from the debt creditor. The fruits and interest belong to the debtor unless from the danger and other circumstances of the obligation it should be inferred that the intention of the person constituting the same was different. So, sa unilateral na obligation, karaniwang walang retroactive effect dahil ang mga ito ay walang bayad. Ang may utang ay walang natatanggap mula sa pinagkakutan kaya ang mga prutas o interest ay pag-aari ng may utang maliban kung mula sa kalikasan at iba pang mga pangyayari ng obligasyon dapat ipagpalagay na ang intensyon ng taong bumubuong parehong ay naiiba. So, Article 1188, the creditor may, before the fulfillment of the condition, bring the appropriate action for the preservation of his right. The debtor may recover what during the same time he has paid by mistake in case of a suspended condition. So, ito yung pinagkakautangan dahil maaaring bago ang katuparan ng kondisyon, magdala ng mga naangkop na aksyon para sa pangangalaga ng kanyang karapatan. So, ang may utang ay maaaring mabawi kung sa parehong oras na bayaran niya ang hindi sinasadya sa kaso ng isang suspensive na kondisyon. Rights pending performance suspensive condition. So, rights of creditor. He may take or brings up appropriate action for the preservation of his right as the debtor may render nugatory to the obligation upon the happening of the condition. So, yon. Ang ibig sabihin ito ay siya ay maaaring gumawa o magdala ng angkop ng mga aksyon para sa pangangalaga ng kanyang karapatan. Dahil ang may utang ay maaaring magbigay ng nugatory sa obligation na kapag nangyari ang kondisyon, kaya maaari siyang pumunta sa korte upang pigilan ang alienation o pagtatago ng ari-arian na pinagkatiwala ng may utang sa kanyang sarili na ihatid o ang kanyang karapatan na nakatala sa titulo ng ari-arian sa rehistro ng mga nagawa. Ang tuntunin sa unang talata ay nalalapat sa pamamagitan ng pagkakatulad ng mga obligasyong napapailalim na isang resolutory condition. Number 2 is rights of the debtor. He is entitled to recover what he has paid by mistake prior to the happening of the suspension condition. This right is granted to the debtor because the creditor may or may not be able to fulfill the condition imposed and hence, and it is not certain that obligation will rise. This is a phase solution which is based on the principle that no one shall enrich himself at the expense of another. So, siya ay may karapatan na mabawi ang kanyang nababayaran ng hindi sinasya bago mangyari ang suspended condition. Ang karapatang ito ay binigay sa may utang dahil ang pinagkakautangan ay maaring hindi tuparin ng ipinataw na kondisyon at sa makatuwid, hindi tiyak na bumabangon ang kanyang obligasyon. Ito ay isang kaso ng isang solusyon nakabatay sa prinsipyo na walang sinuman ang may magpapayaman sa sarili sa kapisalaan ng iba. So, tandaan ito, that the payment before the fulfillment of the condition must be mistake. Otherwise, the debtor is deemed to have implied waived the condition. In any case, he cannot recover what he has prematurely paid once the suspensive condition is fulfilled. So, ito yon. Ibig sabihin na ang pagbabayad daw bago ng katuparan ng kondisyon ay dapat nasa pamamagitan ng pagkakamali. Kung hindi, ang may utang ay ituturing niya ipinapahawatig na tinalikuran ng kondisyon, sa namang kaso, hindi niya mababawi ang kanyang nabayaran ng wala sa panahon kapag natupad ang suspensive na condition. So, Article 1189, when the condition have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the tendency of the condition. So, kapag daw ang kondisyon ay ipinataw na mahilayo ng suspendin ang bisa ng isang obligasyong ibigay ang mga sumusunod na tuntunin ay dapat sundin kung sakaling magkaroon ng pagpapabuti, pagkawala o pagkakasira ng bagay sa panahon ng paghihintay ng kondisyon. 1. If the thing is lost without the fault of the debtor, the obligation shall be extinguished. So, ibig sabihin kung ang bagay ay nawala ng walang kasalanan ng may utang, obligasyon ay dapat patayin. Number 2 is, if the thing is lost through the fault of the debtor, he shall be obligated to pay damage. If it is understood, the thing is lost when it perishes or goes out of commerce or disappears and shuts away, it exists as known, it cannot be recovered. So, ibig sabihin is kung ang bagay ay nawala dahil sa kasalanan ng may utang, siya ay obligado magbayad ng mga pinsala. Ito ay maunawaan na ang bagay ay nawala kapag ito ay napahamak o nawala sa komersyo o nawala sa parang hindi alam ang pagkakaroon nito o hindi na ito nababawi. So 3, when the thing deteriorates without the fault of the debtor, the impairment is to be done by the creditor. So kapag ang bagay ay lumala ng walang kasalanan ng may utang, kahampasan na isasagutin ng ang pinagkakautangan. If the deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment with indemnity for damage in other case. So, kung ito ay lumala dahil sa kasalanan ng may utang, ang pinagkakutangan ay maaaring pumili sa pagitan ng pagbawi ng obligasyon at pagtupad nito sa bayad pinsala para sa mga pinsala o sa alinmang kaso. 5. If the thing is improved by its nature, by time the improvement shall ensure to be benefit of the creditor. So, kung ang bagay ay napabuti sa pamagitan ng likas sa katangan ito, sa pamagitan ng panahon, ang pagbubuti ay magiging pakinabang ng pinagkakautangan. So, if 6, if this improved at the expense of the debtor, he shall have no other right than the granted to the usufructuary. Sementos, kung ito ay pagbutin sa kamisalan ang may utang, wala siyang ibang karapatan maliban sa pinagkakalab ng saang usufructuary. Requisite for application of Article 1189 article applies only if the obligation is real obligation, Number 2 is the object is a specific determinate a thing. Number 3 is that the obligation is subject to a suspended condition. 4 is the condition is fulfilled. And last is there is loss or improvement of the thing during the pendency of the condition. So, kind of loss. Physical loss when the thing perishes when a house is burned and reduced to ash. So, kapag ang isang bagay ay nasira tulad ng kapag ang isang bahay ay nasunog. Number 2, legal loss when a thing goes out commerce leg when it's expropriate or when a thing legal become illegals. During the Japanese occupation, American dollars had become impossible since their use was forbidden by the belligerent occupants. So, kapag ang isang bagay daw ay wala sa commerce league, kapag ito ay inappropriate o kapag isang bagay noon ay legal na naging illegal. Noong panahon ng Japanese occupation, ang mga dolyar ng Amerika ay naging imposible mula nung ang kanilang paggamit ay pinagbabawal ng palaban o nakatira. Civil laws. When a thing disappears in such a way that its existence is known, particular dog has been missing for some time or even unknown, it cannot be recovered, whether it's matter of fact, particular is dropping from a ship at sea, or of law, a property is lost through prescription. So, kapag ang isang bagay ay nawala sa paraang hindi alam ang pagkakaroon nito, isang particular na aso ay nawawala minsan. So, kahit na malaman, hindi ito mababawi kung bilang isang bagay ng katotohanan. Halimbawa, ang isang particle na sinsing ay binaba mula sa isang barko sa dagat o ng batas. Halimbawa ay ang isang ari-arian ay nawala sa pamamagitan ng reseta. Yan. Rules in case of loss, deterioration or improvement of the thing during pendency of suspensive condition. 1 is loss of the thing without debtor's faults. 2, loss of the thing through debtor's faults. 3, deterioration of thing without debtor faults. 4, deterioration of things through debtor faults. 5, improvement of a thing by nature or by time. A thing improvement when its value is increased enhanced by nature, by time, or at the expense of the debtor or creditor. So 6, improvement of a thing expensive of the debtor. Article 1190, when the when the condition have further purpose the extinguishment of an obligation to give the parties upon the fulfillment of said condition shall return to each other what they have received. In case of loss, deterioration, improvement of the thing, the provision which will respect to the debtor are laid down in the preceding article shall be applied to the party who is bound to return. As for obligation to do and not to do, the provision of this second paragraph, Article 11.8 shall be observed as regard the effect of the extinguishment of the obligation. So, ito yung kapag ang mga kondisyon ay may para sa kanilang layunin na pawi ng isang obligasyon, ibigay ang mga partido sa katuparan ng nasabing mga kondisyon ay ibabalik sa isa't isa kung ano ang kanilang natanggap. Kung sakali namang mawala o lumala o mapuputi ang bagay, ang mga provision na may paggalang sa may utang ay inilalatag mo ng artikulo ay dapat ilapat sa partido na nakatakdang bumalik. Kung tungkol sa mga obligasyong gawin at hindi gawin, ang mga provision ng ikalawang talata ng Article 1187 ay dapat sinusunod hanggang sa epekto ng pagpuksa ng obligasyon. Effects of fulfillment of resolutory condition. 1. In obligation to give. When the resolutory condition in obligation to give is fulfilled, the obligation is extinguished, and the parties are obliged to return to each other what they have received under the obligation. A. There is a return to the status. In other words, the effect of the fulfillment of the condition is retroactive. So, kapag natupad ang resolutory condition sa isang obligasyon na magbigay, ang obligasyon ay mawawala. So, at ang mga partido ay obligadong ibalik sa isa ang kanilang natanggap sa ilalim ng obligasyon. A. May pagbabalik sa status quo sa madaling salita, ang epekto ng katuparan ng kondisyon ay retroactive. B. In the case the thing to be returned is legally in the possession of the third person who did not act in a bad faith, the remedy of the party entitled to recitation is against the other. B. Kung sakaling ibig sabihin ay ang mga bagay na ibabalik ay legal na sa pamagmayari ng ikatlong tao na hindi kumilos ng may masamang hangarin, ang remedyo ng partido may karapatan sa pagsasawla ay laban sa isa. C. The obligation of mutual recitation is absolute. It applies not only to the thing received but also to the fruits and interest. So, ang obligasyon ay ng mutual restitution ay ganap na lalapat ito ay hindi lamang sa bagay na tanggap kundi pati na rin sa mga bunga at interest. D. In obligation to give subject to suspension condition, the retroactive admits exception according This obligation is bilateral or unilateral. So, sa mga obligation, magbigay ng napapailan sa suspensive na condition. Ang retroactivity ay tumatanggap ng mga exceptions alinsunod sa dahil ang obligation ay bilateral o unilateral. So, 2. An obligation to do or not to do. In such obligation, the court shall determine the retroactive effect of the fulfillment of the resultary condition. As in the case where the condition is expensive, at courts, the exercise of the discretion may even disallow retroactivity taking into account the circumstances of each case. So, sa ganito nga mga obligasyon, ang mga hukuman ay dapat tukuyin ang retroactive na epekto ng pagtupad ng resolutory condition. So, tulad ng sa kaso kung saan ang condition ay suspensive, ang mga korte sa paggamit ng paghuhusga ay maaaring kahit na hindi payagan ang retroactividad na isaalang-alang ang mga pangyayari ng bawat kaso. Applicability of Article 1189 to pay with obligation to return in the first. So, ang ibig sabihin nito is Article 1191, the power to rescinde obligation is implied in reciprocal ones in case one of the obligor should not comply with the incumbent upon him. The injured party may choose between the fulfillment and the cessation of the obligation with the payment damage in either case. He may also seek rescission, even after he has chosen fulfillment. If the latter should become impossible, the court shall decree rescission claim unless there be just case authorizing the fixing of a period. So this is understood to be without prejudice to the right of the person who have acquired the thing. So in accordance with Article 1385 and 1388 in the mortgage law. So, kinds of obligation according to persons obliged. They are 1. Unilateral. Ito yung when only one party is obliged to comply with the prestation. 2. Bilateral. When both parties are mutually bound to each other. In other words, both parties are debtors and creditors of each other. Bilateral obligation may be reciprocal or non-reciprocal. Reciprocal obligation is ito yung are those which arises from the same cause in which each party is debtor and creditor of the other, such that the performance of one is designed to be the equivalent the condition of the performance of the other. B. Non-reciprocal obligation are those which do not impose simultaneous and correlative performance on both parties. In other words, the performance of only party is not dependent upon the simultaneous performance by the other. Remedies and reciprocal obligation. One choice of remedies in case one of the obligors does not comply with what is incumbent upon him. The aggrieved party may choose between remedies. 2 remedies. A. Action for specific performance of the obligation which damage, or B. Action for rescission of the obligation also with damage. 2. Remedy of rescission for non-compliance. There's principal action for rescission for non-performance under Article 1191 must be distinguished from the subsidiary action for rescission by reason of lesion or damage under Article 1381 and from cancellation of a contract based, for example, on defect on the consent and not in violation by the party of its obligation. Court may be granted guilty party term for performance. The court shall order the rescission claim unless there should be just case for granting the party in default term or period on the performance of his obligation. Obviously, this exception applies only where the guilty party is willing to comply with his obligation but needs time to do so and where he refused to perform. Yan. So, remedies are alternative. So, remedies of the injured or aggrieved party are alternative and not cumulative. That is, he is privileged to choose only one of the remedies, not both, subject only to the exception. In paragraph 2, he may also seek rescission even after he has chosen fulfillment if it should become impossible after choosing rescission of the obligation. He cannot therefore demands it compliant. So, ayan, punta tayo sa limitation and right to demand rescission. 1. Resort to the courts. The rescission contemplated by Article 1191 is judicial rescission or one granted by a court, the injured party has to resort to the court to assert his rights juridically to recover what he has delivered under the contract. To the same article provides the court shall decrease the rescission claim unless there be just cause authorizing the fixing of period. No person can take justice or the law in his own hands and decide by himself what are his rights in the matter. 2. Power of court to fix period. The court has the discretionary power to allow a period within which a person in default may be permitted to perform his obligation if there is a just cause for giving time to the debtor. 3 is where the default incurred was not could be excused in view of the surrounding circumstances. Uh, 3 is a right of a third person if the thing subject matter of the obligation is in the hands of a third person who acted in good faith. Rescission is not available as remedy. 4. Subtennial violation. The general rules the rescission will not be granted for a slight breach of contract. The violation should be subtennial as to defeat the objective of the parties making the agreement. Thus, in a case if it was held that delays on 4 occasions in the payment of rentals for a few days were not substantial violation in a contract of leave to justify rescission because the law is not concerned with that trifles. 5. Waiver of right. The right to rescind may be waiver expressly implied thus the access stamp by the seller to the land sold as security for the balance of the price is implied. Waiver of the right to rescind in case of non-payment by the rescission without previous judicial. The automatic rescission expresses stipulate the parties may validly enter an agreement that violation of the terms of the contract would cause cancellation, therefore, even without judicial intervention of permission. Yan. 11, Article 1191 is not applicable. So, however, there must be at least right notice sent to the other party informing him of the rescission. Extrajudicial rescission has legal effect where such party does not oppose or is subjected to the determination of the issue of the court is still necessary. Number 2, where contract is still executory. So, where there is not performance yet by both parties but one is ready and willing to comply with what is incumbent upon him, the other is not lost. The willing party may by his own declaration rescind the contract without previous judicial decree of rescission. In such a case, it is not necessary that there be stipulation providing for automatic rescission. In any case, where the extrajudicial rescission is caused by the other party, he is free to resort to judicial action, and only the final decision of the court can finally settle whether the rescission was proper or not. So, ayun. Article 1192. In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be them extinguished and it shall bear his own damage. Where both parties are guilty of breach, first infractor known. One party violated his obligation. Subsequently, the other also violated his party of the obligation. In this case, the liability of the first infractor should be equitably reduced. Number 2 is first infractor cannot be determined. One party violated his obligation followed by the other, but cannot be determined which of them was the first infractor. The rule is that the contract shall be them extinguished and each shall bear his own damage. So, that's all for today. So I hope you learned something. Thank you for listening.